Well, hello there, and welcome to the Disability Law Show. I'm John Scholes, Sivan, Tumarkin, James Fireman. We are all back and ready to explain lots of good things for you on the Disability Law Show. We talk about disability rights and injury law as well. A way for you to reach out, 1-855-821-5900, help@disabilityrights.ca is the email address. We'll get to those later on as well. Guys, lots of stuff to get through the show today, including the top 5 most common reasons for insurers for denying insurance claims, like they never do that. So we'll get to that here in just a bit. But a week that was something that's been happening on your desk. Sivan, what's going on?
John, it's interesting. Yeah, I've had the pleasure, actually, of informing several clients over the last few weeks that the insurance companies that we were battling have decided to offer them a reinstatement. And I want to make sure that people understand what that means. Insurance companies will deny a long-term disability claim, or they'll cut you off saying that you're not disabled, they're not disabled enough, there's not enough medical proof, whatever the reason is for why they will deny or cut off your claim. And we, of course, tell people when we review their cases, if they have a case, we will tell you, let us challenge the insurance company. And we do that, and in many instances, that results in an eventual settlement. The insurance company pays whatever that amount is that we negotiate for our clients that's owed to them. But more and more, we are actually seeing insurance companies back off completely. And what does that mean? It means that, let's say somebody comes to me, and that's happened in the last couple of weeks. They've cut this person off, and the person went through the appeals process. They appealed the denial twice, and it took them about a year, and they got denied those 2 appeals, and they ended up coming to us. And so we initiated a legal claim against the insurance company, and I then got a phone call from the lawyer representing the insurance company saying, okay, Sivan, we reviewed everything, fresh pair of eyes, and my client, the insurance company, he says, is willing to reinstate your client. We'll pay you retroactively what your client is owed from when he was cut off and until now, so a year's worth of benefits, and we'll put him back on claim. So again, understand what that means. Only a year ago, they told my client that he's entitled to nothing for whatever the reason was that they've given him, and they do this time and time again. And here you have a year later, after he's exhausted 2 appeals by himself, my client, before I was involved, now we start a legal claim, we put pressure on the insurance company, and not only do they want to pay a settlement, they're willing to pay what he's owed for that year and reinstate him, put him back on claim. That tells you something. It tells you that in many instances, people, when they're cut off, they should challenge these decisions, not by way of an appeal, but by coming to us and letting us help them do a legal claim that puts pressure on the insurance company.
Yeah, I've had that happen to a few of my clients as well, too. And what I really find interesting, especially in this kind of scenario, where you haven't even gone to mediation, which means that I haven't even started to make my argument to the insurance company. The only thing that has changed since the denial and their decision to reinstate is they've become aware that this person that they've cut off or denied has hired a lawyer that knows what they're doing. That is the only difference.
Wow.
They know that it is in capable hands, and they have to take a much harder look at it and make a much more realistic decision. That's it.
Sorry, man. Disabilityrights.ca is where you want to go for information on how you can find our radio show, which has been going on for years. We love doing it. Got a ton of phone calls and response on the radio, and we play the calls back here and we talk about them. First call, in fact, today's call is going to be coming up right now.
When I look at forms for disability insurance from an insurance company, there's a question that says, is condition due to injury or sickness arising out of patient's employment? And there's a yes, no, and unknown checkboxes. I wonder if Sivan can explain what happens if you check yes, what happens if you check no, what happens if you check unknown.
Well, it's a very good question. You have to understand that if you check, first of all, you have to be truthful. But understand that if you check that it's employment related, or your disability is due to a toxic work environment, an event that's happened at work, that really at the end of the day, if tomorrow you were to be placed in a different environment, you could function, the insurance company will likely deny your claim, and most likely legitimately, because that is an employment issue. And of course, we can help with those employment issues because we have employment lawyers. But if you check the box that says that it's not employment related, or perhaps it's employment related, but now it's expanded. Now it's no longer just specific to your place of employment. Now it doesn't matter where you are. It doesn't matter. Yeah, you would not be able to function. At that point, the insurance company should be paying you benefits. But the reason they're asking you that is because they want to see if you check that it's employment related or it's from your employment that you are disabled, most likely they will deny your claim on the basis that you have an employment issue, not a disability issue within the context of the disability policy.
I certainly agree with everything Sivan is saying. The only thing I would add to that is if your disability is a strictly physical issue and it happened in the workplace, you are probably entitled to workers' compensation through WSIB. And in those circumstances, the insurer would be entitled to a deduction for anything that you get through WSIB. And so by all means, you don't want to be dishonest when you're filling out these forms. And if you are, that can really come back to bite you in the end. So you have to fill it out honestly. But even if you check, yes, that it arose out of a workplace issue, because you're being honest, and we're talking about, let's say, bullying at work, something like that. As Sivan was saying, even if you're being truthful about it and they cut you off, that doesn't mean that you don't have a claim if your disability has become generalized, such that you could not do your occupation with another employer.
Guys, every week we get to a top 5 list, and this week coming up after we break is top 5 most common reasons from insurers for denying insurance claims. That is on the way. To reach out, 1-855-821-5900 and disabilityrights.ca. The Disability Law Show continues. Hang on. We're coming right back.
You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Sivan and his team, 1-855-821-5900, or go to disabilityrights.ca. You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. severancepaycalculator.com.
Hey, welcome back to the Disability Law Show as we get to our top 5 list for today, guys. We do one every week. This one is the top 5 most common reasons from insurers for denying insurance claims. First one is simply, you could do another job.
So, John, first of all, there are many reasons why they deny claims. These are the top 5 that we see typically. Right. And yeah, you can do another job. We generally see that when claimants are approaching the 2-year mark. Again, remember that to qualify for long-term disability, in the vast majority of cases, under most LTD policies, you have to demonstrate medically through your doctor's supporting letters for the first 2 years that you can't do your own occupation. It's called the own occupation test. Beyond the 2-year mark, to cross that threshold, the test changes. You have to now demonstrate that you can't do any occupation for which you're suited for by training, education, or experience. And so what insurance companies will typically do is they will try and figure out if they can argue or tell you that you can do something else. Yep. And in some instances, they'll have you seen by a vocational expert. They'll try and do a transferable skills analysis to figure out if, in fact, you can do some kind of another job. And they'll identify even, here are 5 jobs we think you can do. It doesn't matter that you're 63 years old and all your life you've been doing one thing in particular. Now they want you to do 5 other things that you have no clue how to do. But they will tell you that because they think you can do those jobs, you now don't get LTD beyond the 2-year mark. So again, in many instances, really all you need to combat that, to fight that, is to get your doctors, assuming this is in fact correct, and the doctors agree, to say that you cannot do any occupation because of your disability. And we see this mostly with mental health type claims, or even physical types of injuries or illnesses, but when there is a mental health component. So again, remember, if you're cut off at the 2-year mark or close to it, and you cannot do any occupation for which you're suited for, we can help you with that case.
Another issue that comes up with this kind of denial, where they're saying that you can do another job, is that the job that they'll say that you can do often, or that you might actually be able to do, is something that pays you significantly less than you were making before. If you are a professional, a high-income earner earning 6 figures or more, and you become disabled such that you can't return to your job, but perhaps you could do some minimum wage job somewhere, that doesn't mean you're no longer entitled to benefits. The law says first you look at the policy. a lot of policies will actually define how much money you would have to be able to earn before you would be disentitled to continue receiving benefits. In other words, a lot of times they'll say 60% or 65%, right, of what you had been making before. And unless you can make that amount, you're still entitled to your benefits. If it doesn't say anything about that in the policy, the law says it's around 60 to 65%. And unless you are able to do some job that pays you at least that amount, then you're going to be entitled to your benefits.
5 most common reasons from insurers for denying insurance claims. I'm going to throw this one to you, James, because I know you love talking about this. There is no formal diagnosis for your disability.
It's a completely improper denial. It's fundamentally improper, and this is coming directly from our Supreme Court of Canada. They have said very, very clearly the focus of the analysis is not on the diagnosis. And we understand this because the medical community over time understands what's going on better and is going to be able to put labels on things that were previously undiagnosable. They just didn't understand what was happening. Over time, that's how medical science develops. And so we know this, and because of that, it's not necessary that you have to have a formal name for whatever it is that is causing your disability. You just have to legitimately be suffering from symptoms that are preventing you from working. And if that's the case, if the doctors are saying that you are not able to work because you have these symptoms, whether or not they understand what's causing these symptoms is irrelevant. The only issue is if you have a disability, symptoms that are preventing you from working. And if that's the case, then you're entitled to your benefits.
I can see that coming to light with a lot of mental disabilities that they don't, as you say, have a label or diagnosis for.
Yeah, absolutely. And there are also complex physical disabilities, neurological disabilities that we see as well that are just simply difficult to diagnose. And I'm not going to go too far on this because I'm not a doctor. It's not my job to understand exactly what it is that is causing someone's disability, especially if the medical community can't. But we do see that. We do see that with clients not infrequently. And where they're denied for that reason, it's completely improper.
Number 3, fellas, is this one. And again, we've talked about this ad nauseum on the show, and we're going to keep talking about it till people get it straight. That is insufficient medical documents supporting your disability. Again,
this is something very important for people to understand. If the insurance company is saying that there's not enough medical documents or not enough support to support your claim for disability, ask yourself this: have I provided them with a doctor's letter, with a letter from people who are treating me? Maybe there's a psychotherapist or a psychologist, a psychiatrist, a surgeon, a family doctor. If you've provided some kind of documentation from people who are treating you, even if it's one doctor who says that you cannot work because of your disability, you have provided sufficient medical documentation. Now, sometimes it does happen that the doctors are not providing enough light about your disability. For example, they may say, I've seen letters where they say, you know, I've treated this person for X amount of years, here's what I've treated them for, in my opinion, they can't work. Well, they have to explain why you can't work. What's the nature of your disability? I mean, you know, if we're dealing with somebody who's paralyzed, really we understand why. But if you're dealing with depression, things like that, you want to have some more meat to the report. But again, it comes down to something much more basic. If you've provided support, letters, reports from people who are treating you to the insurance company, where there is a conclusion that's explained in a logical way that you cannot work because of what you're experiencing, illness, injury, or a combination of both, you have provided enough medical documentation, and we can challenge the insurance company and we can force them to pay.
You want to reach out, by the way, anytime, 1-855-821-5900. We are talking the top 5 reasons insurers give for denying your disability claims. James, I'm not even going to look at the card because I know what the next one is. You are not totally disabled.
Yeah, this is something that we see in many, if not most, of the denials. And you know what we should be saying is the insurance company says that you're not totally disabled. Right. And I use the air quotes because you will see quotes around it. And the reason you see quotes around it is because the term totally disabled is in fact a defined term in your policy. And that's really important to understand. If you just hear the words or see them without recognizing their importance, totally disabled to most people would suggest that you're suffering from a disability that prevents you from doing almost anything, prevents you from being able to feed yourself, to bathe yourself, to change your clothes. To be able to just get around the house. That's how most people would think of the term totally disabled. But that has absolutely nothing to do with how totally disabled is defined when you're dealing with disability benefits. And I say this because that is what's written in the policy. If you go to your policy, your disability policy, and you look on the definitions page, you will find right on there alphabetically the term totally disabled. And what it means is simply this: you are suffering from an injury that prevents you, or injury or illness that prevents you from being able to do the occupation you had at the time you became disabled, or after 2 years, any occupation. That's it. It doesn't mean anything more than that. The analysis is entirely on your ability to work. It has nothing to do with you being able to function on a daily basis around the house, or what you might generally think the term totally disabled to mean. It is just about whether you can work.
John, just adding something else, nothing to add to what James said, except for the fact that it confuses medical doctors as well. Right. And I actually had a gentleman contact me saying, listen, I've listened to your show, both the radio as well as the TV, and yeah, my doctor says I can't work, but that same doctor who looked at my policy, because he gave him the policy to look at, the doctor says, no, you're not totally disabled. I can't write that you are totally disabled. So what happens is that doctors themselves, not just doctors, anybody who is a treatment provider, they get confused by the lingo. And so this doctor, not out of any ill will, told this person, don't bother challenging the insurance company's denial because you're not going to win. Well, it's a good thing that he called me. I mean, the doctor should be focusing on treating the individual, not giving legal advice, just like I'm not going to give medical advice. But again, this term confuses not just regular people out there, but the people that are trying to help them.
And by the way, that's entirely intentional. That's entirely
from the insurance company's perspective. Yeah, I agree.
Completely by design. The entire purpose of using the term totally disabled is to confuse claimants and to confuse doctors.
Whoever came up with it that many years ago to use those two words is a genius, because they've probably shaken so many people off claim.
You know what? That phrase made the insurance industry, I have no doubt, billions of dollars.
Yeah.
Because people simply don't understand that it doesn't mean what they think it means.
Yep. Top 5 reasons insurers give for denying your claim. Number 5 is this, guys. We've heard this again so many times. You hear it on TV. You don't qualify because of a pre-existing condition.
Well, listen, pre-existing condition clauses, first of all, we have to look at the specific one that they have. But, you know, they're very limited in scope. Generally, they say that within the last 90 days or 90 days before you had the policy, that you began the policy, that you didn't seek any treatments or weren't diagnosed with any issues relating to the disability that now you are claiming under. Oftentimes, they will say that there is a pre-existing condition, but it's actually very different than what your disability in fact is. And one thing that comes to mind, which is a case we're dealing with right now, is a person who suffered from diabetes, but ended up going on disability because of ulcers that he developed that end up leading to an amputation of a leg. And so, therefore, he's not able to do his work. And the insurance company is saying, well, you had diabetes, which was a cause.
That was the gateway to the...
Exactly. But that's not what the test is. The actual ulcers and the amputation, that was not pre-existing. And so, you see, they will tell you something. You may think it makes sense. Your doctor may think it makes sense. But you have to test whatever they're telling you. You have to challenge. You have to challenge, and you have to understand that they're going to try and use whatever clauses they have in the LTD contract to exclude you from the policy or deny your claim. And this is when you come to us, because we'll tell you if, in fact, that is the case or not.
The important thing to really understand here, though, is that if the insurance company is suggesting that you have a pre-existing condition, the onus is on them to prove that. That's an exclusion. They have to show that it's more likely than not that you suffered from what is defined by the policy as a pre-existing condition. And when a court were to look at that, they will define that very narrowly. That's the way courts look at these exclusions, the things that prevent you from getting your benefits. They make it as difficult as possible for the insurance companies to be able to apply it. And there are all kinds of rules that apply before an insurance company is able to actually successfully deny or cut off a claim because of something that they say is pre-existing. If you've been able to work with this pre-existing condition and you weren't actively seeking treatment over a certain amount of time before you became insured under the policy, you're going to be entitled to your benefits, even if you've been diagnosed with it 10 years before. So there are a lot of ways, even if it is a pre-existing condition, that you can very legitimately challenge that kind of a decision.
All right, coming up here, how to deal with an uncooperative insurance adjuster. That is on the way. The phone number in the meantime, 1-855-821-5900 and disabilityrights.ca. Lots more of the Disability Law Show is on the way. Don't go anywhere.
You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Sivan and his team, 1-855-821-5900, or go to disabilityrights.ca. You thought you had a secure job. You didn't see it coming. Now what do you do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back to the Disability Law Show. I'm John Scholes, Sivan Tumarkin, James Fireman. We mentioned several ways for you to reach out, phone calls, emails. There's also mydisabilityquestions.com. You type it in there, you leave it. These guys will answer it very quickly. First one for today, fellas, Tina. First one up says, my sister has been on disability for 6 months. She has a new insurance adjuster, and he's been very disrespectful to her and her doctor. He's now asking for more medical information. There you go, saying that what he currently has isn't enough. My sister's afraid to ask for a different adjuster because she doesn't want her payments to stop. Is there anything we can do?
First of all, I think that Tina, her sister, should be documenting everything. And what I mean by that, I mean to the extent that she has correspondence by email with this adjuster, she's communicating, she should not be afraid to say and to document the tone of the conversations. She should also be telling her doctors what is going on. It's very important that we have contemporaneous records within the medical records that show how her stress and anxiety and all the other symptoms that she has are being aggravated by this new adjuster. Look, there is zero reason why an adjuster should be aggressive. They should be professional. It would be nice if they would be empathetic, but really there is zero reason for them to be aggressive, and she should be asking for a new adjuster. She can be asking for the manager, she can be speaking with the manager, but here's the problem. The problem is that insurance companies and a lot of these adjusters, they understand the vulnerable state that a person is in, and they understand the precarious state that they're in. And so they use that to bully individuals. And someone like Tina's sister may end up just disengaging from the whole process. Now, the fact that this adjuster has now been asking for more documentation, I think he's priming her claim for a denial, for a cutoff. So she's done the right thing by contacting us, and we can get in touch off air, and I can give her more hints and strategies on how to deal with this adjuster. But it's important that this is documented both by way of an email to the adjuster or a manager asking for someone else and explaining why, as well as to her own doctors to explain how this entire scenario and behavior from the adjuster is aggravating her condition.
Help at disabilityrights.ca is the email address we use, and you can use as well anytime. I want to send these guys an email. Aaron's up says, my cousin was in an abusive relationship and has mental issues as a result. She's been on disability for almost 2 years on the advice of her psychologist. Her insurance company says that she should be better by now with all the treatment she's received, and that they will be cutting her off in a few months. What can she do about this? At least she was warned, right?
Yeah, the insurance company is simply playing the odds here that someone who is suffering from mental health issues isn't going to fight back. First and foremost, my advice is, as always, listen to your doctor when it comes to your health issues. That's the only person you should be listening to. Not an adjuster, not a lawyer, it's your doctor. If your doctor says that your health is going to be jeopardized by returning to work, you can't go back to work, and it's as simple as that. And if that means that your insurance company is going to cut you off because of it, as long as it's documented that your doctor is saying you can't go back to work, then we're going to challenge that decision, and they'll lose.
Yep.
They'll lose. It's as simple as that. You cannot put your health at risk. The other really important thing is we don't have to wait around. If they've already told Aaron that, or Aaron's cousin, that they're going to be cutting him off in a couple of months, we can start the claim now. We don't have to wait. We can bring the claim now and therefore take less time to get to resolution, because if his cousin's going to be out of benefits for some amount of time, you don't want to wait until you're actually not getting those benefits anymore. We can do that today.
And if that cutoff does come, you know what's going to be at the bottom of
Exactly.
it. Chance for you to appeal.
Now, John, what happens a lot of times is that people are told they're going to get cut off in the future, in 2 months, 5 months, 6 months. And remember, the cutoff letter, the letter that advises you that on a certain date your benefits will stop, at the end of that letter, there's going to be a paragraph that invites you to appeal. And we talk about that all the time. So people think, I have time. I'm still getting paid. For another 2 months, 3 months, let me go through the appeal process. Why should I call Sivan or James? Let me just go through it and see what happens. I'll tell you what's going to happen. What's going to happen is that they're going to drag their feet. Eventually, the payments will stop. You're going to get a denial, and you're going to panic. And what happens in many of these instances is you try and appeal again because you're going to be embarrassed to call us, which you should not be. You should be calling us immediately. Don't go through the appeal nonsense. You know, at the very least, if you think you want to appeal, at the absolute very least, give us a call. At least we'll give you some strategies with that. We'll try and dissuade you because it's fruitless. But at least we'll help you with it. We'll help you navigate the process. Don't do it on your own. There is a power imbalance.
I'm going to flip back to mydisabilityquestions.com for another one, guys. Sheila says, my husband was in a serious car accident. He lost his left arm, and suffered multiple fractures. He has worked as a contractor and hasn't been able to work since. He was approved for short-term disability but was denied LTD because he wasn't disabled enough. I don't understand how the insurer can say that. Should we appeal the decision? There's a line. How can we show that he is disabled?
I got nothing on it. I honestly,
right?
I have no idea, and I'm really excited to find out how they got to that decision.
Yeah.
I cannot wait to get the insurance file because there can only be tortured logic to come to the conclusion that someone who's lost an arm isn't disabled. It just doesn't make any sense. I can't explain it. I've got nothing that I can add to that. Just simply, it's very simple to challenge this, and it should be very obvious. And I would suspect it's one of those where as soon as they see that a lawyer is on the file, they change their mind pretty darn quickly.
Yeah. Just kidding.
Yeah.
Yeah,
John,
exactly.
I'll tell you, I understand why they're doing it. I think that they're taking a chance. They're taking a chance that this person, they're rolling the dice because in many instances, people will walk away because they have too much stuff that they're dealing with. So they're going to put it on the back burner. So here's what does happen sometimes. They will either put it away, not even engage in the appeal process, which of course we say don't do, and they'll contact us, when it's too late. Right? Because people don't realize you have 2 years from when you're first denied to start a legal claim, not an appeal, a legal claim. And so we do have people who are now watching the show being educated, or people who are watching the show and telling their loved ones who haven't watched the show but who have been denied unjustly LTD 3 years ago, 4 years ago. I have people contacting me who've been denied 10 years ago. And I got to tell them, I can't do anything for you. And when I do the math, in terms of how much money they have now left in the pockets of insurance companies, it's obscene. So again, telling people out there, do not hesitate to contact us. It costs nothing to talk, to get this information.
James, last minute or two. Final salvo is yours, buddy.
Sure. One thing we often hear from clients or potential clients is that they're really concerned about what the process is going to be like when they start a legal claim. And they're worried that it's going to have a big impact on their life and that they're not going to be able to make their own decisions. And nothing could be further from the truth. Once you start a legal claim, you're putting it in our hands. You're in fact taking a lot of the burden off of you and putting it on us. If you have a medical decision to make, that's not up to us to decide. That's up to you and your doctors to decide. I do not get involved in medical decisions. I want to know what's happening. So once you make a decision based on your health, I'd like to find out, please. But you don't have to consult me or seek my approval for that. Likewise, if you want to return to work, if you start a legal claim and 8-9 months down the road you're feeling better and feel like you can go back to work, you don't have to ask my opinion. That's something you decide with your doctor. And if your doctor gives you the go-ahead, then you can go back to work. The only two things I tell to my clients about how to live their lives when we start a claim is, number one, be careful on social media. Yep. And number two, listen to your doctor. If your doctor is telling you to do something or not to do something, listen.
Good stuff, guys. We'll wrap it for another show. You want to reach out, 1-855-821-5900. We discuss mydisabilityquestions.com. You can go there anytime you like. Same goes for the email. It is help@disabilityrights.ca. If you want more details about this show, what we do, what they do, how to find the radio show, that is disabilityrights.ca online. Check it out. We'll join you again, and you join us for another edition of the Disability Law Show. Thank you.